The adoption of the UN Declaration on the Rights of Indigenous Peoples in 2007 was a major achievement by Indigenous peoples and their allies. The declaration has political, legal, moral, and symbolic implications. It is the boldest recognition of ethnicity as a factor in international relations since the inception of the United Nations. Based on its substance and drafting history over 25 years, I can say that the declaration has three pillars, which are interconnected. One, the right to self-determination. Two, the right to lands, territories, and resources. And finally, three, cultural rights. The declaration has to be read as a whole to make the connections among its 46 articles. And in analyzing an indigenous issue under any of the three pillars, one has to bring in elements of the other two pillars as well. During the drafting of the declaration, indigenous peoples put forward a number of concepts that were not accepted as human rights and were eventually included in the text, especially the following 5 points. First, the significance of collective rights as human rights. Second, land rights as collective human rights. Third, the crucial importance of the right to self-determination for indigenous peoples, including respect for their own governance systems and their right to free, prior, and informed consent. Fourth, spiritual rights and spiritual relation to the land. And fifth, recognition of a rich body of cultural rights as a response to ethnocide, in other words, the erasure of groups through the destruction of their cultures. So, despite continuing challenges, are there examples of improvement on the ground? Indeed, we have some such examples in the form of referenda, constitutional and legislative reforms, judicial decisions, and formal apologies. For example, following negotiations between Denmark and the Home Rule government of Greenland, a referendum in 2008 affirmed Greenland's autonomous status. In 2001, the Inter-American Court of Human Rights ruled in favor of the Awastingni community in their petition against the state of Nicaragua, finding that the right to property, as recognized by the American Convention on Human Rights, protects customary land and resource rights for indigenous peoples as well. This was the first international court decision to address indigenous peoples' rights positively. Others have followed since, both in the Americas and in Africa. In Latin America, there have been major legislative and constitutional changes, recognizing the existence of indigenous peoples and the nature of states as multicultural, such as in Bolivia, Ecuador, and Guatemala, and recognizing a number of indigenous languages as official. In some so-called developed countries, we have witnessed state recognition of historic injustices and the issuance of formal apologies. In 1997, Norway's King Harald V publicly apologized to the Sami people for the repression and injustices they suffered through the policy of Norwegianization. Australia followed in 2008, declaring a formal apology to the lost generation of Aboriginal peoples due to the country's boarding schools policies. This was followed by a similar apology by Canada in 2008, again regarding boarding schools. Japan also in 2008 recognized the Ainu people of Hokkaido as indigenous peoples of the country. In 2010, El Salvador likewise recognized the indigenous peoples of the country while also providing a formal apology. The same year, the US issued one of the least known apologies due to inadequate publicity. In 2016, Taiwan also apologized to the indigenous peoples of the country. The question remains, are apologies enough? It is clear that for any apology to be meaningful, indigenous peoples concerned must participate in a substantive manner through their own governance structures.